Good morning, ladies and gentlemen. This is the hearing of the appeal against the Court of Appeal judgment. The ground of appeal is that special measures should be allowed for the defendant throughout the entire course of the trial. I have three submissions to make in favor of my argument. My first submission is that the judge has erred in deciding that the defendant had no significant impairment of intelligence and social functioning. The second submission is that by not allowing the use of intimidatory throughout the entire course of trial, would it deprive the defendant the right to a fair trial. And finally, my third submission would be the availability of intimidatory for vulnerable defendants. Now, going on to my first submission. The judge has erred in deciding that the defendant had no significant impairment of intelligence and social functioning. He simply concluded the assessment by saying that there was no evidence of specific difficulty in taking instructions from the defendant. Now, based on the expert evidence provided by Dr. Hathaway, when she noted that the defendant had the tendency to yield to leading questions and to change his answers in response to negative feedback. She further noted that the defendant had low cognitive functions and would struggle to understand the evidence and had the tendency to go along with what he did not understand during the trial. She recommended that the defendant was in need of an intermediary. This was further supported by Dr. Smith's recommendation in her report. Now, the judge in his assessment mentioned that the defendant's IQ was around the range of 70 to 79. Now, this range is somewhat borderline or low average. Now, this is a clear indicator that the defendant had an impairment of intelligence. Referring to the Criminal Practice Direction 3D.2, it states that the court is required to take every reasonable steps to encourage and facilitate the attendance of witness and to facilitate the participation of any person, including the defendant. This would include a witness or defendant to give their best evidence and enabling a defendant to comprehend the proceeding and engage fully with his or her defense. Now, referring to the case of Crown against Everett, when the defendant pleaded guilty after the trial judge ruled that the admission made to the police should not be excluded. The defendant was age 42 while with a mental age of 8. He appealed against his conviction. The court allowed the appeal and held that while considering the circumstances that existed at the time of the confession, the test was objective, not what the officers thought about the defendant's mental condition, but what his mental condition actually was. Had his mental condition been considered, it was inevitable that the officers should have ensured the presence of an independent, matured person. The judge has erred in considering only the tapes of interviews and not the medical evidence. Now, that being said, the judge in this case has erred in deciding that the defendant had no significant impairment of intelligence and social functioning, given the fact the judge noted the defendant was suffering from low intelligence and further expert evidence suggesting that he had a tendency to drive drunk. Furthermore, applying the criminal practice direction, the defendant could not give his best evidence or comprehend the proceeding nor engage fully with his defense. Moving on to my second submission. My second submission is that by not allowing the use of intermediary throughout the entire course of trial, it deprived the defendant the right to a fair trial. Now, it is understood that the statutory power to appoint an intermediary for the defendant is governed by Section 33BA of the Youth Justice and Criminal Evidence Act 1999, which is not enforced now. Thus, the power now lies with the judge, which is governed by common law. The starting point will be the case of Crown against Steve Oak Youth Court, where Justice Openshaw stated that it is the court's duty to ensure that the defendant had a fair trial, not just during the proceeding, but beforehand as he and his lawyers prepare for trial. The defendant needed someone to befriend him and help him, both during the trial itself and in preparation for it. In short, he needs an intermediary. This was further reinforced in the case of Crown against Great Yarmouth Youth Court, where Justice Meeting stated that there is a right, which may in certain circumstances amount to a duty, to appoint a registered intermediary to assist the defendant to follow the proceedings and give evidence if, with the assistance, he would not be able to have a fair trial. Followed by, in the case of Crown against Cox, a judge at the preliminary hearing had ordered the use of intermediary, but none could be found. The Court of Appeal examined what accommodating measures the trial judge had devised in order to ensure that the defendant was following the proceeding. The court held that the absence of an intermediary had not there deprived him of a fair trial. It would always be for the court to adopt the processes to ensure that the individual is not disadvantaged. Now, bearing that in mind, it seems that the court are open to the use of intermediary to fully enable accurate fact-finding and the protection of liberty. In the instant case, the judge was aware that the defendant was suffering from low intelligence, and thus the judge should have allowed the use of intermediary for the entire course of the trial, so that the defendant would be able to understand the evidence which is again seen clearly, and thus being able to participate effectively in the trial. By doing so, the judge ensured that there's no inequality of arms and justice is being served. Finally, my last submission will be the availability of intermediary for vulnerable defendants. Following the decision of Crown against Secretary of State, where he stated that there are two roles in which a defendant intermediary can play. First, it was to assist throughout the trial, and second was to assist during the defendant's evidence. Now, looking at this decision, the defendant in the instant case would fall under the second role, in which the intermediary would assist the defendant throughout when the defendant is giving out his evidence. However, the Court of Appeal decision in Rashid went one step further and adds that when deciding whether an intermediary is needed, the starting point is the assumption that the advocate has undergone specific training and is able to ask questions in a way which effectively could make it unnecessary to have an intermediary intervene. And even if intervention was needed, the judge could do that, which is similarly what happened in the case of Crown against Cox. Under the Criminal Practice Direction, paragraph 3F13, the court says that it is a rare case where the threshold of disability is crossed, such that an intermediary is required when the defendant gives his evidence, and for an intermediary to be present for the whole trial will be very rare. The Court of Appeal then set the standards for the advocate when determining what is necessary for the particular defendant. The judge must take into account certain things about the advocate before him. The first is that the advocate will have undergo specific training and must have satisfied himself or herself before acting for the Crown or the defense. That the training enabled them to conduct the case with proper professional competence. Now, given that, in deciding whether intermediary is needed, the court looked at whether the advocate had undergone specific training and are they competent enough to handle the case. The Court of Appeal did define as to what they meant by professional competence, which is the ability to ask questions without using tag questions, by using short and simple sentences, by using easy to understand languages, by ensuring that questions and sentences were grammatically simple, by using one-ended prompt to elicit further information, and by avoiding the use of tone of voice to imply an answer. An advocate would, in this court's view, be in a serious dereliction of the duty to the court, quite apart from the breach of a professional duty to continue with any case if the advocate could not properly carry out this basic task. Now, based on this, it seems like the courts are making it harder for the use of intermediary, while at the same time it is making sure that competent advocates are being employed to deal with vulnerable defendants. There are indeed benefits and detriments to such decision. The benefit would be that a defendant would have competent advocate representing them. However, the detriment is that by having competent advocate, judicial intervention would increase, thus making the judiciary less impartial. Now, furthermore, with the courts now looking at the advocate's competence and skills in deciding whether the need of intermediary shows that the courts are trying to limit the defendant's rights further. That being said, I would argue, it is argued on behalf of the appellant, Mr. Rashid, that the court should allow special measures and that intermediary should be allowed for the entire course of the trial. Thank you.